This video is made possible by Practical Defense Systems, the best online security training at the lowest prices. You can start your security career today online at pdsclasses.com. Check them out. Hi, I'm Joel Persinger. I'm the Gun Guy. Thank you very much for all of your support of GunGuyTV. I'm super grateful for the fact that you provide the support you do by watching and listening and so on. With that in mind, I want to remind you to check out these other locations because YouTube has a tendency to shadow ban me, age restrict my videos, unsubscribe my subscribers, or just delete videos periodically. In fact, I just did a video the other day, I think yesterday, talking about what's going on in Israel right now, and they age restricted it, even though all it was me sitting in a lawn chair underneath my avocado tree talking about my opinion of the war. So this is the kind of stuff that YouTube does. If you're concerned about that and you would actually like to get to the videos, I do encourage you to go to either Twitter or, well, which is now X. I'll get it eventually. Go to X, which used to be Twitter, or go to Rumble. Those are the two most mainstream places where you can go. And stuff won't be deleted, shadow banned, or otherwise censored. So that's a pretty good idea. You'll find those links in the description. You can also listen to the Gun Guy TV Firearms podcast. That's on your favorite podcast player. But you'll also find the video versions on both Twitter and Rumble. And I believe I post them on YouTube too. I think we do. I don't have to ask, but I think we do. So there you go. All right. I got an interview with Dan O'Kelly, who's retired from the ATF. He's been fighting with ATF in court as a professional witness and training police officers and like that on how the federal laws actually work ever since he retired. He is a very close friend and a really good guy, and he's going to tell us about what happened just, I think, 2 days ago in court to protect the members of one particular organization I think you need to join, and Rare Breed Triggers, the maker of the FRS, the Forced Reset Trigger. So let's go talk to Dan. Dan, thank you very much for joining me. It's been a while since we've talked. I'm really looking forward to chatting with you. We've got a lot to talk about with Rare Breed Triggers and the victory in court with I've plastered all over the screen here, big win for National Association of Gun Rights and Rare Breed. Well done, NAGR. Outstanding. They're doing some good work there. What can you tell us about where this stands? Because a lot of people own these triggers, and what the victory entails. You've been on the case for a while.
You know, I'm surprised to hear you say that a lot of people own them, because from what I'm seeing, they all fell out of boats and they're at the bottom of some lake somewhere.
Yeah, okay. I don't personally know anyone who owns them, ATF. So if you're contacted, you want to talk to me. I know nothing. I see nothing. I'm like Sergeant Schultz from the old Hogan's Heroes show. So there you go.
I hear the price of boat insurance has skyrocketed lately due to all these acts.
Yeah, I imagine it has.
Anyway, let me just start off with saying that we need to keep in mind that this thing with Rare Breed has been going on 2 years since ATF served them with their cease and desist letter. No one at Rare Breed at the company has ever been arrested. There have been 3 individuals that I know of that have been charged with having them in Texas and Puerto Rico. And I'm told there's somebody else out there. I'm not part of that case. If there is somebody or other people out there beyond those 3, could be. But even in those cases, there were other charges filed also in those prosecutions. But no federal prosecutor will indict the company, which ATF says has made and sold 100,000 unregistered machine guns. So what does that tell us? Well, they won't touch it because 3 other former ATF experts and myself testified 2 years ago that these aren't machine guns. So, just picture anybody else out there making 100,000 machine guns and going public with it, and they're still not in jail. So this is a weak case going in, is my point with all that. ATF knows these things aren't machine guns, but the White House tells them what to do, so they're going to pretend it is. So a week ago today, I testified in Fort Worth, Texas in federal court in the National Association for Gun Rights case against ATF, trying to win an injunction against ATF to leave people alone because they're not machine guns. A couple months ago, August 1st and 2nd, I testified in New York in the hearing where ATF was trying to get their restraining order against Rare Breed to keep them from selling these things. And of course, that judge, being a Biden appointee, uh, gave ATF that restraining order. So no big surprise there. So here we are. We have the decision that came out Saturday from Judge O'Connor. This is the same judge. If I'm not mistaken, this is the same judge. It's hard to keep track lately. Fortunately, we've had a lot of pro Second Amendment wins, and but I think this is the same judge that gave us the decision on AR receivers and lowers, 80% lowers and whatnot, and a couple of other really good cases. So this judge gets it, as you said earlier. I can drone on. I don't know if you have any questions you want to start with, Joel.
Yeah, I mean, you said this judge gets it. I read the decision, in anticipation of chatting with you because, as you know, I'm like you. I'm running around like a lunatic half the time, batting the table here. So I read through it. I was really impressed by the fact that the judge, not only did he get it, he got it. He could sit down and explain precisely why the ATF regulation goes well beyond their authority and why a force reset trigger is not a machine gun and does not make the gun into a machine gun. And so I'm reading his decision. I felt like I was reading something you wrote. It was just outstanding. So he really, really did get it. Now, this, I should explain, is not a final decision in the case. This is a preliminary injunction to keep people from being prosecuted or sued, or keep Rare Breed from being prosecuted or sued, and to allow them to continue business while the case is being carried along. And my understanding, over the years talking to attorneys, is that when a judge decides to do this, to enjoin one party or the other, a lot of the decision, and even in his decision he explains it, is he has to look at who's more likely to prevail in the case down the road when the case is done. So if there's a likelihood that you're going to win, then there's a real strong reason for the judge to have an injunction on the other side. And so in this case, the judge, he came right out and said that the ATF regulation is likely a violation. It's an overreach of their authority, and so the National Association of Gun Rights and Rare Breed are liable to win. So he gave them the injunction. This keeps people who are members of the association. Boy, that's a key, I think, as I read it. If they're members of the association, then they can't be prosecuted or sued or sent threatening letters or anything like that as this court proceeds. So if you have a force reset trigger, here's my little hint from GunGuyTV, and you're not a member of the National Association for Gun Rights, you might want to join. I would want to make sure I was a card-carrying member, because that way you are then part of this, and ATF has to leave you alone while this case proceeds. At least that's the way I read it. You're not an attorney, neither am I, but that's kind of what I got from it. And then they can't go after Rare Breed either. They got to leave them alone and let them do their business. And this is a higher court, I think, than the New York court where the other judge ruled against them, isn't it?
Well, I'm not sure that it's a higher level. It's a U.S. district court. That was the Eastern District of New York. This was the Western District of Texas, or Central.
I see.
District
so it probably
of
just applies within that district, then, I would imagine. But I don't know. I don't know how that applies. That's interesting.
Yeah, the judge in New York granted a restraining order against Rare Breed selling FRT-15s. This judge gave an injunction against ATF, saying you cannot prosecute anybody who has one. So I'm waiting to find out what
What the heck does that mean, and where does that leave?
But the ones that are out there in circulation, you cannot be busted for having them if you're an NAGR member. So if you're not a member, like you just said, and you have 2 brain cells, become an NAGR member. I plan to become one. I'm already a member of a couple of other Pro 2A groups, but I intend to join NAGR too, because I had the pleasure of meeting their founder and chairman during this meeting. Fantastic. As a matter of fact, I was able to meet with Chris McNutt, the head of Texas Gun Rights. He was present in court during this hearing, and plan to join that one too, even though I don't live in Texas, but great organization. Yeah, if you'd like, I can tell you some of what happened in the hearing, some
Please
interesting
do. It'd
things.
be very interesting to know, I think, as we're looking at, as far as this is really not a Second Amendment case as much as it was a case of of looking at the statute that the Congress actually passed and ATF's overreach in redetermining what that statute meant, which they don't have the authority to do, as opposed to was it constitutional or not. The judge didn't get into that because that really wasn't the question. It was, did ATF have the authority to do this? And the judge is of the opinion that they did not. And so am I, and so are you. So that's kind of interesting that we're winning on multiple fronts here. We're getting a lot of court case wins for the Second Amendment, but some of them actually aren't necessarily Second Amendment cases. Some of them are First Amendment cases, and they're actually adjudicated on a different basis. But in the long run, they're a win for gun owners. So I think it's kind of interesting to find out what happened in the case. Yeah, if you could tell us, that would be great.
Sure. Well, in the New York hearing, myself and one of my colleagues, I, on one hand, would like to name him, but I don't know if he wants to be named, so I won't. But another former ATF expert, we both testified for rare breed. ATF had one of their firearm enforcement officers, a guy by the name of Anthony Ciravolo, testified for them. ATF brought up a number of issues that all, of course, were nonsense. I'm going to tell you what those are and why I say they're nonsense in New York. However, for this Texas hearing, Judge O'Connor told both sides, you each get one witness and you get 90 minutes for your witness. We're not going to go on for 2 straight days like we did in New York. So ATF's guy, Anthony Ciravolo, he got up there and he testified, and he is a knowledgeable guy. I will give him that because I believe I'm a fair person. On the other hand, he said a couple of things that were complete nonsense, and I called him out for them. For instance, at one point during his direct examination, he said that in a standard AR-15, the disconnector stops the cycle of operation. When I said that, I'm sitting in the gallery and I'm thinking, wait a minute, what is this guy doing? These ATF firearm tech guys, I've seen it so many times, I couldn't tell you. They try to dazzle the court with BS at times. And I have to say it that way because it's just what they do. If the other side of a case does not bring an expert to court, they will confuse the judge and or the jury with technical jargon that these people don't understand. And the next thing you know, their eyes roll back in their head and they just go, ATF, I trust them. I don't know what anybody's talking about. So I hear Ciravolo say this, and he said another thing, which I'll get into in a second. But right after he was done testifying, we reconvened and they put me back on the stand, and I said, his statement about the disconnector stopping the cycle of operation is a complete falsehood. And you saw a couple people's jaws drop. I'm calling this guy out. I said, I testified, quote, he is either trying to intentionally mislead this court or he doesn't know what he's talking about. I said, when a disconnector traps the hammer during the cocking step of the cycle of operation, nothing stops other than the hammer. The extraction step continues. The ejection step occurs, feeding step, chambering step, the locking step. Cycle of operation doesn't stop. Why would he try to convince the court otherwise? He also testified that in an M16, the auto sear serves to time a machine gun. He tried to liken that to the locking bar in an FRT-15 in a rare breed trigger, saying that the locking bar serves the same purpose in an FRT-15, that it times the gun, therefore it's a machine gun. I said, according to that, in reference to that statement, again, complete falsehood. In the cycle of operation has to occur in order in every gun. The 8 steps that occur for every shot fired, they have to occur in order or the gun doesn't work. The only thing that the auto sear and the locking bar have in common are that they both pivot and they're both struck by the bolt carrier. But their purposes are completely different. The auto sear releases the hammer and the locking bar releases the trigger. They have nothing in common as far as what they do. So I'm sure I'm not one of his favorite people at this point, but
No, but I'm glad, there's an old Oingo Boingo song, I think it's Oingo Boingo, you blinded me with science. And so often
yeah.
they've adopted the term, you baffled me with BS. And so it's really kind of good that you called them out on that. They need to be called out on that more often than not. The other thing I was reading is apparently the ATF was using the argument that it's one pull of the trigger, which is what their whole rewording says. And I love the fact that the judge got in there and said, no, what the user is doing has absolutely nothing to do with anything according to the statute. It's what the trigger is doing. So perhaps just, if you wouldn't mind, if you could explain why a force reset trigger is just a semi-automatic trigger, kind of slightly enhanced, and how fast the gun shoots doesn't matter. It's how the gun shoots fast. I would really appreciate that, because I
Sure.
get a little foggy on it. I have a feeling other people do as well.
Yeah, when we all got into Fort Worth Sunday night, the attorneys and I had a chalk talk session about the hearing the next day. And I suggested to them, tongue in cheek, just to get a chuckle. I knew they weren't going to do it, but I said, guys, your opening statement tomorrow ought to be, if it please the court, the definition of a machine gun hinges on the phrase single function of the trigger. I said, but now the court is going to hear ATF talk all day about what the shooter's finger does. It has nothing to do with that. It's about what the trigger does, not what the shooter's finger does. And that's been ATF's position through this whole 2 years, is what the shooter's finger does, this continuous pull, pressure, pull, whatever. And that's just it, whatever. It's about what the trigger does. My testimony was that for every shot that comes out of the end of an FRT equipped gun, the trigger serves to disengage from the hammer. Hammer, of course, its firing pin fires a shot. The bolt carrier then forces the hammer back into the cocked position. The hammer forces the trigger back into the reset position where it re-engages with the hammer. And before another shot is fired, no matter how quickly that happens, the trigger has to be pulled to the rear again, consciously and intentionally by the shooter, to again disengage with the hammer and cause another shot by a single function of the trigger. So it is absolutely not a machine gun according to the statutory definition. So, ATF along the way has hung on all these phrases that have nothing to do with it. Pressure, pull, continuous single pull. They've tried to, in the process, give themselves the power to rewrite this definition. And this is a power they don't have, to your point. And this is what several federal judges have continued to tell them. The judges in the receivers case, the braces case, the bump stocks case, yet ATF continues to propose to have the authority to rewrite a definition, a gun definition in federal law, and they don't.
Well, and even this judge, in his decision to issue the preliminary injunction, pointed out, this isn't a direct quote, but it's pretty close, that if Congress wanted to change the definition, they know how to do that. And he even wrote in there, they know how to do that. I think they don't need ATF to help them do that. If Congress wants to change the definition, that's Congress's purview to do it. ATF's job is to work within the bounds of the definition that Congress has given. What I find really fascinating about this is that it's chipping away at this sort of unelected fourth branch of government, the regulatory state, that our founders never envisioned. We were given three branches of government: the executive branch, the legislative branch, and the judicial branch. And nowhere in the Constitution does it appear that we also were given by the founders of our country this administrative state branch, and yet they tend to operate that way. So I'm pleased to see the court start chipping away at that, because I have a feeling it's going to end up not just applying to our Second Amendment rights, but the overreach of federal government through the administrative state all over the place. So I'm very happy to see that this is happening. Where do you think this case is going? It looks to me like it's going toward victory for gun owners and for Rare Breed and for NAGR.
Yeah, there's already a victory. However, it's not done yet. ATF is not going to quit because it hasn't gone as high as it possibly can. ATF's lawyers are on salary. You know, they work 9 to 5, Monday through Friday. So it doesn't cost ATF anything to pursue this. They're going to appeal it. It's going to go to the Court of Appeals. If ATF loses there, they're going to try to get it to the Supreme Court. I don't know if the Supreme Court will hear it or not. They have the choice of whether they hear a case, um, but it may even go that high. So this is going to take some more time until such time that the Court of Appeals shoots Judge O'Connor down. If that were to ever happen, we're good. If you're an NAGR member.
Yeah, that last part's important. So if you're in California, you can't legally have them anyway. I think California made them illegal under state law, just like the binary trigger and those kind of things. They don't like those in restrictive states, these crazy restrictive states like California. But federally is what we're talking about. So if you're in California, New York, New Jersey, one of these super restrictive states, you want to check your state laws because they might not be legal under state law. But we're talking about federal law here. Under federal law, they have to follow, ATF has to follow what the actual definition says. So if you're in a state where you can legally own it and you're concerned about federal law, you want to join NAGR because if you read the decision, my understanding is that the preliminary injunction is against the enforcement against members of the association and against members and against the employees of Rare Breed and Rare Breed themselves. So if you're not a member of NAGR and you have an FRT trigger, you want to make sure that you join. I'll stick a link in the description if I remember to do it, but it's pretty easy to find. So
let me offer this that, I'm in the state of Florida, and in Florida, we have a state law against any device which enhances the speed that your semi-automatic fires without that device attached. So you can't have them in Florida either. They call it the bump stock law, although it covers more than just bump stocks. But even with that, I plan to join because any support you give to a pro 2A group, especially NAGR in this case, you're going to strengthen them. And any 2A win is a win for all of us because even if this fight doesn't affect you directly, the next one will. So, make the organization stronger and help them win the next thing. There were a couple of other points that ATF's been using in these hearings I could mention if you're interested, but otherwise,
please do. Please do. I am interested. I think these details are important because it's important for gun owners to understand how this stuff works. This this stuff because you're in court all the time. Attorneys know their version, their part of it. I'm just a layperson, and it confuses the snot out of me. So, any confusion you can clear up would be great.
Don't sell yourself short, Joel. You're the man.
Thank you. I appreciate that.
ATF's position used to be on these that, hey, this is a forced reset trigger. And at one point, I called the company, and before we went to the next hearing or wherever we were at that time in this timeline, I said, wait a minute, guys. All triggers are forced reset. The only difference being that the FRT-15 is forced into the reset position by the hammer. I said, but every AR-15, every other semi-automatic, I said, for that matter, every gun, the trigger is forced into the reset position by a spring. It may not be forced into that reset position by the hammer, but it's still, when you release or you lessen pressure on the trigger, your trigger return spring forces that trigger into the reset position with your hammer or your striker. So all guns are a forced reset trigger. So even a double action revolver, you pull through your double action pull, the gun fires, you lessen your pressure on the trigger, and the trigger goes back to the reset position for you to fire another shot. Is that a machine gun now? It's a forced reset trigger. Hey, ATF, what are we missing here? Once we brought that up, ATF abandoned that position. Then they insisted that because the shooter doesn't release the trigger after each shot, the FRT-15 is a machine gun. I countered that the shooter doesn't release the trigger on any AR-15 after each shot. Again, all you do is merely lessen pressure on it. So we've peel away a lot of the layers of the onion and what ATF does. In the New York hearing, they had this, and in their technical exam reports, they had this famous thing called the zip tie test. So they took an FRT-15 equipped AR and they put a plastic zip tie around the trigger and they tightened it just to the point where the trigger would snap on an empty chamber. Then they put in a magazine chamber around, and soon as the bolt carrier went into position, went into battery, um, because there was tension on the trigger is pulled by the zip tie, and that fires the gun. Well, now the bolt carrier forces the hammer into the recock. The hammer forces the trigger into the reset. That stretches the zip tie back into its original oval position versus a round position because there's an elasticity. And you got a string of bump fire. It wasn't full auto fire. It was just bump fire, the same way a slide fire stock works or a Hellfire trigger assist or whatever. And I argued to AT, number one, when they brought this up in New York, I was asked my opinion about this, and I called it little more than a parlor trick. ATF wasn't too happy about that, explaining that all this is a modification on their part that caused bump firing, and bump firing is not full auto. And for that matter, even if it was, the person who puts the zip tie on the gun is the one who modified it into a machine gun. So the whole thing was nonsense.
Well, we get back to behavior again. And then the question becomes, I'm a firearms instructor and I have been for 20 some odd years. What is the difference between that and my teaching somebody how to learn the reset on their gun?
Exactly.
So if you want to fire quickly, you want to make sure that you learn where is the reset on that trigger on that particular firearm so that you don't let the trigger all the way out. You just let it out to the point of the reset and press again. And once you've learned that and you can lock the gun down, you can fire very, very quickly, a la Jerry Michalek and others who can do things like that. This is part of the process of learning how to shoot fast. And so it's not a matter of the fact that the gun shoots fast. It's how does it shoot fast? And so and the other thing I thought the judge pointed out brilliantly, which I'm aware of and so are you, is if I clamp down, if I get a force reset trigger and I clamp down on that trigger, the mechanism fails. If I do that with a fully automatic weapon, the mechanism does not fail. It keeps on going. Right. And so there's a kind of a feel to that trigger. You've got to get that exactly right. And you pointed out they tightened up the zip tie just to that point as this sort of parlor trick thing to make it look like something that it's not. But anybody that's ever fired a force reset trigger knows if you press the trigger too hard and you really clamp down on it, then it just fails. It won't work because that's not the way it's designed.
That actually stops the cycle of operation, and as a result, the gun cannot be ready to fire again. ATF did this, what I call the zip tie trick, not only with plastic zip ties, but with a worm type radiator clamp, and then with a stainless steel braided cable tie. Same thing. It just has flexibility, and it goes from round oval, and you get, repeated firing, but each shot is through a single function of the trigger. So again, they're trying to baffle the court, trying to intentionally mislead the court. And that's what I hate about what I see going on. If you present the facts and you win your case, so be it. But let's tell the truth for starters.
Dan, we've talked about this a lot. Is there anything else we should talk about, do you think?
I think we're good for this time. We'll save anything else maybe for next time.
I'm looking forward to it. Take care, my friend, and stay safe.
Will do. Thank you.
Thank you very much for watching the entire video. I'm really grateful when you do that. It helps a lot with the algorithm. I don't know anything about algorithms. What do I know about that? Hey, if you would like to help out with Gun Guy TV, you can join Gun Guy TV Crew. That's a place where you can get exclusive content you can't find anywhere else. Right now, you can do that on Patreon or Locals, if you happen to be on either one, or you can go to GunGuyTVCrew.com. I have submitted an application with Twitter to be able to have a subscription part there, and that'll be Gun Guy TV Crew on Twitter. So if you want to wait for that, you can do that too. Either way, it does help me keep this effort going. I can tell you, a little kind of inside baseball secret, and that is that Gun Guy TV is not self-supporting. I have to support it out of my pocket. So to the degree that you can help me, I would really appreciate it. Thank you very much for all of your support. Have a wonderful week, and wherever you go, whatever you do, stay safe.